Good morning, Dan Guerin on behalf of Abdul Khan, who's to my right. Abdul, can you state your name?
Abdul Mohammed Khan, Your Honor.
This hearing opens with what appears to be a routine procedural request, but the implications go far beyond scheduling. The defense is not just asking for time, they are setting the stage. An adjournment in a probable cause conference is often used to negotiate, reassess evidence, and potentially reshape the direction of the case before it escalates. But here, there's an added layer. The defendant is not a local resident. That immediately raises the stakes. When someone has international ties, every decision the court makes becomes more sensitive. The judge is not just managing a case, he is managing risk across borders. So while this sounds simple, it is actually the first moment where the court begins evaluating how much flexibility it can afford. The defense is subtly testing the system. How much room is there to maneuver before the court tightens control?
Right. And what are we doing?
Your Honor, I am asking for an adjourned PCC date. I did inform Ms. Hughes I would like to address a very quick bond condition, but can we have an adjourned PCC date for continued negotiations?
Yes, I guess.
Thank you.
October 5th, 2023, 9 a.m. Bond continued. Well, you wanted to address an issue on bond. Go ahead.
I did, Your Honor. My client is from Canada. He's a Canada national. He came here to visit his sister who's in medical school and got in a fight with his brother-in-law, who's the victim on this case. He is asking permission to go back to Canada. He's enrolled in university there. He's got some exams coming up next week. His parents are in my lobby. He is going to come back. His passport is being held at the Sheriff's Department. That was a condition from Magistrate Fink. But I would ask Your Honor permission for him to leave, to go back to school. He can attend the PCC by Zoom, and any further litigation or sentencing he would, of course, come back for.
Oh, boy. Let's hear what Hughes has to say about this. Ms. Hughes.
Honestly, Your Honor, that was pretty good. He's a little convincing. Mr. Guerin did reach out to me beforehand, which I always appreciate. I'm going to leave this with the court. I know that everything Mr. Guerin just said is correct. And I don't have a strong objection to it. So I'm going to leave it with the court.
All right. And Mr. Guerin, you're looking for his passport to be returned so that he may reside in Canada.
Exactly right. He can't, of course, cross the border without it. So yes, please, Your Honor.
What I indicate is the defendant may have his passport returned to him and may reside in Canada. Defendant must return when ordered by the court or any in-person proceeding.
This is a major judicial decision, and it comes with serious implications. The court has now allowed the defendant to regain his passport and return to Canada. That is not a small concession. It is one of the highest risk bond adjustments a judge can make. Because once a defendant leaves the country, the court's authority becomes significantly harder to enforce. The only safeguard here is the condition that he must return when ordered. But that condition relies heavily on compliance, not control. This decision likely reflects a combination of factors: the defendant's background, the lack of strong objection from the prosecution, and the structured argument presented by the defense. Still, this is a calculated risk. If the defendant returns, the system works. If not, it exposes a major vulnerability. That's the weight of this moment.
In all other respects, defendant's bond will continue.
Thank you very much, Your Honor.
Thank you, Your Honor.
They are back calling. Court calls the case of the People versus Irvin Tolliver.
Alex Jablowski for the People.
I'm here. Sandra White on behalf of Irvin Tolliver.
Mr. Tolliver, can you unmute and state your name, please, sir?
Can you hear me, sir?
Yes, I can hear you now. State your name.
Irvin Tolliver.
Thank you. Okay, what are we doing on this case today?
Unfortunately, Your Honor, they were having technical difficulties, so Mr. Tolliver and I in that breakout room were not able to talk. So I don't know if you want to give us another breakout room after Mr. Dawson, because Mr. Dawson is my last client before Mr. Tolliver.
That was a question to me as to whether or not I want to give you a breakout room.
Right. I didn't know if you want to do Mr. Rayshawn Dawson first and then give me a breakout room, Mr. Tolliver. As you see, I'm trying to give you a
just want all
suggestion.
your cases to be done.
I'm trying to help you along.
This moment highlights something critical about courtroom management. The judge is not just making legal decisions, he is controlling the flow of the entire system. Here, the judge is dealing with delays, confusion, and technical limitations all at once. Instead of allowing the process to stall, he steps in and actively redirects the situation. That line, "I'm trying to help you along," is more than just a comment. It's a signal of authority and expectation. The court expects efficiency, preparation, and clarity from attorneys. When that breaks down, the judge intervenes to restore order. This is not just about moving cases faster, it's about maintaining the integrity of the process. Because if the system slows down too much, it affects fairness, scheduling, and ultimately justice itself.
Is one of the next two files. He's one of the next two custodies. He's in Zoom.
And he's in Zoom, and that's Ms. White's case.
Yeah.
Which one is it?
It's Dawson.
Dawson?
Yeah.
All right, let me do Dawson. We'll then throw you into a breakout room. Hopefully then, since he's at the Bureau of Prisons, we'll try to accommodate you. But
Thank you.
so I'll pass that one. Court does call the case of the people of the state of Michigan versus Rayshawn Dawson.
Yes, I'm here.
Nicole Hughes on behalf of the people.
Sandra White on behalf of Rayshawn Dawson.
All right, he stated his name. What are we doing on this?
Your Honor, I did receive the videos from Ms. Hughes earlier this week, so I'm asking for an adjournment to review those with Mr. Dawson.
About a bond reduction.
Can we review this? Can I get an adjournment for 1 week?
1 week, September 28th, 2023, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. And now she's ready. She can go in with Tolliver. And then I'll hold and then do this. You all set?
Oh, yeah. You're good to go.
Court does call the case. People versus Kalina Waters.
Nicole Hughes on behalf of the people.
First Assistant Public Defender Kalina Anderson with an on behalf of Kalina Waters. Ms. Waters, please state your name.
Kalina Waters.
All right. I have a drug court referral.
Yes, Your Honor. We'd ask for an adjournment of the PCC for the referral for drug court. And if I may address her bond.
Briefly.
Thank you, Your Honor.
Sure.
I've had a chance to speak with Ms. Waters. I did speak with Ms. Hughes regarding this as well. Ms. Hughes at the time, I believe there was a warrant in this case before. She didn't have stable housing at the time and contact to get in touch with our office. She's now provided good contact information. I've supplied that to the court as well. She knows about the access points and can now appear for subsequent court dates. We'd ask for a personal bond. I don't believe there's any objection to that.
That's correct, Your Honor. She's in custody for a failure to appear. Ms. Anderson reached out to me beforehand, gave me all the information I needed. I said as long as she had stable housing and a game plan for how she'll be appearing here, as well as at her 15th district court cases, that I wouldn't object to her being released to appear on.
Now we move into a situation where the court is weighing rehabilitation against risk. The defense is arguing that the defendant's previous failures were due to instability, not intentional avoidance. That's a powerful distinction. Because if the issue is circumstance, it can be corrected. If it's intent, it's much harder to trust. The prosecution doesn't object outright, but they carefully frame the concern. Compliance depends on stability. This is where the judge has to make a judgment call. Is the defendant now in a position to follow court orders consistently, or is this just another temporary improvement? These decisions are rarely black and white. They rely on credibility, history, and the strength of the plan presented. And here, the court is balancing all three.
I'm not going to have necessarily an objection, but part of the problem is she was also ordered to community corrections and failed to appear. Wow.
Okay, well, I think that it also goes into the same argument, Your Honor, with her failures to appear in court. It was just that she just wasn't stable at the time. And now she has that taken care of. She's able to get where she needs to get and go where she needs to go for the court.
Hate it when you guys agree. All right. What I will do is previous bond is reinstated. I'm gonna need a new order at some point with her community corrections order, so she needs to appear at community corrections. All right. And then how much time are we gonna need for the drug court referral?
Your Honor, I'd asked for 30 days for that, and just for the court's information, Ms. Waters has that 15th district court case that she will go to court on the 25th, so she won't be able to report to community corrections at least until after that date. That case has a bond that's holding her.
Okay. You want an adjournment for 30 days?
Yes, please.
October 19th.
Okay. Probable cause October 19th, 2023, 9 a.m. Previous bond is reinstated, and I'll sign this. I don't know what was it. All right, thank you.
The judge's decision here is measured and controlled. Instead of granting a full bond reduction or making a drastic change, the court reinstates the previous bond. That tells you something important. The judge is not fully convinced, but also not dismissive of the defense's argument. This is a middle ground ruling. It maintains structure while allowing the defendant another opportunity to comply, but it also comes with expectations. The mention of community corrections is not optional. It is a condition that must be followed. This is how the court creates accountability, not through punishment alone, but through structured oversight. The message is clear. You are being given another chance, but it comes with responsibility.
What is the mean?
Court does call the case of the people versus George Higgins.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Ready, Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. George Higgins. Mr. Higgins, please state your name for the record.
George Higgins.
Thank you, Judge.
What are we doing?
This is a case where Mr. Higgins is going to have to enter a plea on this file. I don't know if you prefer to have him waive the circuit court and enter that plea, or you are prepared to take
Yes.
that. Okay, then he'll waive, please, Judge.
All right. Sir, your counsel's indicated you're waiving your right to a preliminary examination.
Yes.
That is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand that?
Yes.
And you understand you'll not have that hearing, you'll proceed to circuit court.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Feaster.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
October 4th at 1:30 p.m. with Judge Conlon.
October 4th, 2023, 1:30 before Judge Conlon.
Thank you, Judge.
Thank you. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Ismail Abdul Aziz.
Good morning, Your Honor. Maria Rosinski on behalf of the people, seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Good morning. Permission to practice is granted.
Thank you. And good morning, Your Honor. Assistant Public Defender Emily No on behalf of Ismail Abdul Aziz. And Mr. Abdul Aziz, I'm sorry, can you unmute and state your name?
Ismail Abdul Aziz.
All right. Thank you. All right. What are we doing?
Your Honor, we are asking for an exam date and to address one of the bond conditions.
Preliminary examination in person will be set for October 3rd, 2023, 9 a.m. That is before Judge Barr. As to bond.
And so, Your Honor, Mr. Abdul Aziz has been on a Soberlink device for about 5 months, I believe a little over at this point.
I do not see that he's ever had a positive test. It looks like it's been completely smooth, completely compliant, what we want to see for the past little over 5 months. The case itself is over 2 years old at this point. It was not charged until February of this year, and he has actually been sober since the date of the offense 2 years ago. If Your Honor would consider removing the condition at this time, it is expensive and it is adding up.
Response.
Your Honor, this is an operating with a high BAC third offense case. The officer was called for an unresponsive driver who was unconscious, and his blood draw result was 0.409. The people would ask that the bond conditions stay the same.
There'll be no change in the bond. You can bring that up before Judge Barr after the preliminary examination if necessary. Bond will continue with all of its conditions. Thank you.
Thank you.
Court calls the case, People versus Joy Barra.
Good morning, Your Honor. Allie Zend on behalf of the people seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Good morning. Permission to practice is granted.
Thank you.
Good morning again, Your Honor. Dan Guerin on behalf of Joy Barra, who's in custody. Joy, can you unmute and identify yourself?
Yes, my name is Joy Vera.
Okay. What are we doing?
Your Honor, I'm ultimately asking for an adjourned PCC date. At the risk of getting yelled at, I did inform Ms. Kirby. I was going to address bond very briefly. May I do so?
Is this a risk of getting yelled at by Ms. Kirby?
That happens frequently. It's more I'm concerned about you right now, but.
Oh, okay. Well, all right. You need an adjourn date on it, first of all?
I do. Yes.
October 5th, 2023, 9 a.m.
This exchange reveals a different kind of courtroom dynamic, tone and control. The defense attempts to address bond conditions while also requesting an adjournment, but the judge immediately redirects the process. There's a clear structure that must be followed, and the judge enforces it. This is not just about procedure, it's about maintaining order. When attorneys try to combine multiple requests without clarity, it can disrupt the flow of the hearing. The judge's response ensures that each issue is handled in the correct sequence. It may seem strict, but it's necessary for consistency. Courtrooms operate on structure, and when that structure is followed, decisions become clearer and more efficient.
All right, go ahead, Esteban.
Quickly, Your Honor, I am asking for a 10% provision. Her bond is currently set at $100,000 cash or surety, along with the 10% provision. If she's able to post, I would have no objection to either a scram or GPS tether, both if such as exists. Your Honor, this offense occurred on her property with her mother. Her mother is the victim who lives in the house on the same property. She'd, of course, abide by a strict stay-away order from her mother while this case proceeds through. To my knowledge, her only criminal history is an OWI from 2020. This offense, of course, surrounded alcohol, which is why, again, I would not object to a scram tether or a GPS tether or both.
Response.
Your Honor, in this case, we would ask that bond remain the same. In this case, she broke into the house, her mother's house, grabbed her by the neck, pushed her to the ground with both hands. The victim fell to the floor. She struck her head on the trim of the closet and her back hit the floor. She then kicked the victim while she was on the ground multiple times. And then while she was laying on the ground, she poked her and told her to get up. Her daughter had to call 911 and she left. In this case, the victim suffered a concussion, a broken vertebrae in her back, a left leg injury, and an injury to the back of her head. So we would ask that bond in this case remain the same.
Anything else, Mr. Guerin?
Two very quick facts, Your Honor. She walked into the house. Again, it's on the same property. She did not break in. And secondly, she did not grab her mother's neck. The police report reflects very clearly her mother grabbed Joy's neck. In fact, the police took pictures of Joy's neck with injuries on it. Otherwise, the facts are consistent with what what Ms. Zenda said. I believe a 10% bond provision would be appropriate. She's neither a flight risk nor a danger, especially if she's not going to have any contact with her mother.
Well, I would happen to disagree on that. I will motion for bond reduction is denied.
This is one of the most intense moments so far because it involves conflicting narratives about a violent incident. The prosecution describes a severe assault with serious injuries, while the defense challenges key details of that account. When facts are disputed at this level, The judge must rely on the severity of the allegations and the potential risk. And in this case, the judge chooses caution, denying the bond reduction signals that the court views the situation as too serious to allow increased freedom at this stage. This decision is not about proving guilt, it's about managing risk while the case proceeds. And here, the risk is considered too high to relax the conditions.
And bond will continue.
Thank you very much, Your Honor. I appreciate it.
Thank you, Your Honor.
Court calls the case of the People versus Aaron Tolliver. They're ready, finally.
Alex Jablowski for the people.
Sandra White on behalf of Urban Tolliver.
Mr. Tolliver, can you state your name, please, sir? Is he here? Oh, there he is. Mr. Tolliver, you'll need to unmute, sir. Or have somebody unmute you. We got you.
Urban Tolliver for the record, sir.
Thank you. All right, what are we doing?
Your Honor, there has been an offer from the people, and I believe hopefully we got the plea form over this morning.
That what?
Hopefully the plea form was sent over this morning.
Did you? Do you have it?
I'm checking my email. No, I do not.
I don't have a plea form.
Okay, so I guess we'll have to adjourn this matter. We can put the offer on the record.
They need 6 weeks to adjourn it. He's not going to be released anytime soon.
Not to July 8th.
Okay. So what is 6 weeks now?
November 2nd.
Probable cause conference will be adjourned November 2nd, 2023, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls the case, People versus Patrick. Is it Patrick?
Nicole Hughes on behalf of the people.
Yes, you know who I'm talking about.
First assistant.
I don't know why. That his name always gives me a problem, and it shouldn't. Anyway.
First Assistant Public Defender Kalina Anderson with on behalf of Mr. Petiprin. Mr. Petiprin, will you state your name, please?
Patrick Petiprin.
This section reflects a quieter but still important part of courtroom workflow. Case progression without resolution. The defense is requesting a short adjournment because not all related charges have been finalized yet. That matters more than it seems. When multiple charges are still developing, proceeding too early can create inefficiencies or even contradictions later in the case. So instead of forcing movement, the court allows time for consolidation. This is strategic patience. It ensures that when the case does move forward, it does so with a complete picture. The judge grants the request without resistance, which indicates this is a reasonable procedural step. But here's the key point. Delays like this are not just pauses, they are preparation windows. They allow both sides to strengthen their positions before the next phase.
And I apologize, sir, for whatever, it just wasn't coming out. All right.
I understand.
What are we doing?
Your Honor, we adjourned this last week for some cases to come through. One has been sworn to. We're still waiting for the other two. So we just asked for a 2-week adjournment for that purpose.
Probable cause conference, no, October 5th, 2023, 9 a.m. Bond will continue.
Thank you, Your Honor. Mr. Petiprin, call me as soon as you can, okay?
Okay. Do you have any other hearings today? Or
I'm here all day, but call me as soon as you can.
Okay.
Okay.
Thank you.
I apologize.
Thank you, Your Honor.
Court does call the case, People versus Iwana Johnson. 2 cases.
Nicole Hughes on behalf of the people.
And Edward Drukas on behalf of Jana Johnson in the case 5625.
Mr. Overwater.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender with and on behalf of Ms. Johnson.
Sorry, Judge.
State your name, please.
Assistant Public Defender.
All right. State your name, ma'am.
Jana Johnson.
All right. What are we doing on these cases?
Your Honor, with regard to 5625, we'd like to set this for preliminary examination.
And on the other matter?
Same, Your Honor.
What are we doing on the other matter? Mr.
The
You
same,
want
Your
the
Honor.
same
We'd
thing?
ask for a preliminary examination, David. Ask for the same date.
Preliminary examination in these matters will be set October 3rd, 2023, 9 a.m. before Judge Perry.
Now we enter a case where the defense attempts to shift the narrative toward rehabilitation and stability. Employment, housing, and lack of criminal history are all presented to support a bond reduction. These are classic defense arguments, designed to show the defendant is grounded and unlikely to flee. But the prosecution counters with something far more serious: weapons charges and prior concerns. That immediately reframes the situation. The judge now has to weigh stability against potential danger. And in cases involving weapons, courts tend to prioritize public safety over personal circumstances. This is where many defendants face a hard reality. Being employed and stable helps, but it does not neutralize the severity of the charges. The court's focus shifts from who the defendant is to what they are accused of.
Bond will continue. Thank you.
Your Honor, may we briefly address the issue of bond?
Very briefly.
Your Honor, my client has almost no criminal history. She's employed as a cleaner at U of M in the dining hall. She's been there 7 or 8 months. She resides in Ypsilanti with her grandmother. Bond is set in my case at $10,000. I would ask for a personal recognizance bond if she's able to be released on Mr. Drukas's case as well. So she can get back to work and come back to court and resolve these matters.
Except it appears that she's failed to appear, but or maybe not. Maybe they were set that way out of the gate.
I believe they were, Your Honor.
Pardon?
I believe they were set that way by the magistrate. I don't believe she's failed to appear on this matter, and she has 2 attorneys now to help her keep track of her court dates. So that don't expect that would.
Is there a response other than the fact that I've got 2 weapons charges?
Well, I mean, there's the fact that there's 1 weapons charge. She's got a warrant out for her arrest for Mr. Overwater's case when she commits Mr. Drukas's case, which is another CCW and actually a very violent case. I requested $25,000 at her arraignment, so Magistrate Fink was being kind, I think.
Motion for bond reduction is denied. Bond will continue.
Thank you.
And Judge, what was the date? I'm sorry.
October 3rd.
Thank you.
Thank you. Court calls the case, People versus Justin Scott.
Stan Bernstein for Justin Scott, Your Honor.
Sorry, Judge Alec Jablowski for the people.
Justin, can you please say your name for the court?
Justin Scott.
All right, what are we doing?
Your Honor, we're going to waive the preliminary examination.
Preliminary examination in person will be set October 3rd.
No, we're waiving, Your Honor. We're waiving the.
Oh, you're waiving.
Sorry.
Okay. No, it broke up there. That's fine. Is that true, Mr. Scott? You're waiving your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
This is a critical legal turning point, the waiver of a preliminary examination. By waiving this hearing, the defendant is giving up the opportunity to challenge whether there is enough evidence to proceed. Instead, the case moves directly to circuit court. That can be a strategic decision. Sometimes the defense chooses to waive because they believe the outcome is inevitable, or they want to move faster toward negotiation or resolution. But it also means forfeiting an early chance to test the prosecution's case. The judge carefully explains the rights being waived, ensuring the defendant understands the consequences. That's essential for the record, because once this step is taken, there is no going back. The case is now moving forward at a higher level with higher stakes.
People also waive their right?
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Bernstein.
Your Honor, please waive reading. Mr. Scott stands mute.
Defendant having waived former reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
October 4th, 4th at 1:30 p.m. with Judge Conlon.
October 4th, 2023, 1:30 before Judge Conlon.
Thank you.
Thank you. Bond continued. Court does call the case of the People versus Daniel Bellis.
Ready,
Alex
Judge.
Jablowski for the people.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of my client who was previously labeled as SpongeBob. But Mr. Bellis, please state your name for the record.
Daniel Bellis. Sorry, I guess my daughter got a hold of my Zoom.
All right.
Thank you, Judge.
Okay.
I've spoken to Mr. Chabalowski and to Mr. Bellis. This is the first PCC. We're asking for a adjournment so we can meet and go through the evidence a little further and see if we can get an offer on this file.
Probable cause conference, October 5th, 2023, 9 a.m.
This is another procedural adjournment, but it serves a very specific purpose: evidence review and negotiation. The defense explicitly states they need time to go through the evidence and potentially reach an agreement. That tells you the case may be heading toward a plea discussion rather than trial. These moments are where many cases are quietly resolved. It may not look dramatic, but it's highly strategic. Both sides are evaluating strengths, weaknesses, and possible outcomes, and the court facilitates that by granting time. Efficiency in the legal system doesn't always mean speed. It means moving cases in the right direction at the right time. And here, the direction is clearly toward deeper evaluation before any major decision is made.
Thank you, Judge.
Bond continue. Thank you.
Thank you, Mr. SpongeBob.
You had a deep voice for SpongeBob. Anyway, court calls the case People versus Raheem Bragg.
Maria Rasinski on behalf of people.
Everybody said, wondered how I know that.
Torshell Feaster, again, Assistant Public Defender, on behalf of Mr. Raheem Bragg. Mr. Bragg, please unmute, turn on your camera, and state your name for the record.
Raheem Bragg.
All right. Thank you, sir. All right, what are we doing?
Thank you, Judge. I've spoken to Mr. Bragg. He has another matter in circuit court that we also have to resolve. I believe he wants me to request a dismissal on this file today because he says he hasn't received some video information. I've told him I did not think that would be fruitful, but that is what he is requesting at this time, Judge. I'm asking
If
for
that's a motion, it's denied.
Thank
Go
you.
ahead.
I'm asking for a brief adjournment so that we can sit down and meet and try to figure out both the circuit court case and this file.
I'd like to ask a question, Your Honor.
Okay, go ahead.
Yeah, I'd like to know, I mean, you probably couldn't answer this, but from the prosecuting attorney's office, what is the holdup on the footage
Right
that I May 5th, I believe? Yes, May 5th from a case.
Sir, let me stop you right now because you're going to get yourself into a whole bunch of trouble. First of all, you don't get to question the prosecuting attorney, okay? That is one of the reasons why if you have a question, you give that question to your attorney so the attorney can put it in a proper form if it's necessary to have an inquiry to the prosecutor as to some issue.
This is one of the most tense exchanges in the entire proceeding. The defendant attempts to directly question the process and the prosecution, but the judge immediately shuts it down. And that's not arbitrary. It's foundational courtroom structure. Defendants do not directly interrogate prosecutors. Communication must go through legal counsel. This ensures that arguments are properly framed and legally appropriate. But beyond the rule itself, this moment exposes frustration. The defendant feels unheard, claiming lack of communication and missing evidence. That frustration is real, but the courtroom is not the place to bypass procedure. The judge reinforces control, not just to maintain order, but to protect the integrity of the process. Because without structure, proceedings can quickly spiral.
I did,
That's
Your Honor.
how it worked.
I did, Your Honor, and I never get, as far as this case, I've never been reached out as far as even I don't have nothing on this case. I don't have a discovery packet. I've never reached out to be sat down to discuss my case. All I do is go to court for probable cause hearing. That's just it. And I get it adjourned based on video footage that seems to never be something that's talked about, period. I'm the only one concerned about video footage that I haven't.
Mr. Bragg?
heard of possibly being initiated to talk about.
Mr. Bragg, I am free tomorrow.
Can I just say this? And,
I mean, my
let's just be
apologies, and I don't have
real.
an attitude.
No, hold it. Let's just be real clear about this. Because August 17th, you were supposed to be in court. You weren't here. So don't tell me that you're always coming, because you're not.
I spoke
I'm
with
done.
the clerk and was told that
I'm done. I'm adjourning this out. You are not going to co-opt this proceeding. Don't tell me something that's not true.
Your Honor, excuse me, Your Honor. I had spoke with the clerk that day because I was with a private investigator on my other case that I'm dealing with.
I issued a warrant. You weren't here.
I did not have.
I issued a warrant. No matter how much you keep talking, nothing's going to change.
I mean, I'm not arguing, but I feel like I have the right.
Yes, you are, because I'm telling you to be quiet. Mr. Feaster, how much time did you need? You're probably going to need more time than the 2 weeks, because somebody's got to be checked.
Yes, please, Judge. 3-4 weeks, please, at least.
And what is this 3 to 4 weeks in regards
there
to?
There he goes again. What do you want?
I would like to
What's
know
your question?
3 to 4 weeks adjournment in regards to.
He wants to sit down and talk with you. The thing you were complaining about.
We've been saying that for the past couple months that we were supposed to sit down and talk. And I have not been reached out in regards to that matter at all.
You can come in tomorrow, Mr. Bragg. And let me know what time you're free. Sorry, Judge.
Mr. Feaster?
Judge, we can have 3 or 4 weeks.
Once he's in court, I can give him an exam date.
Is that what you prefer, Mr. Bragg?
Here, the court shifts from conflict back to resolution. After a tense back and forth, the judge redirects the focus toward moving the case forward. The defense requests time, the defendant pushes for action, and the judge offers a concrete solution: set a preliminary examination date. This is how courtroom momentum is restored. Instead of continuing the argument, the judge channels it into a procedural step. That's effective judicial control. It prevents escalation and keeps the case on track. The decision to move forward quickly also suggests the court wants to avoid further delays in a case already experiencing friction. This is a reset moment, taking a chaotic exchange and turning it into structured progress.
I mean, yeah, we can ask for a dismissal in regards to us not.
Let's just set it for exam then, please, Judge.
All right. Yeah, we can. We can. And it's not something that I waived. I didn't waive my probable cause.
Jeez, oh Pete. Mr. Feaster, as the attorney of record, what would you like me to do, sir?
Judge, let's just move this case forward. We'd like the soonest possible exam date, please.
Well, soon as possible, we can set it this Tuesday.
Thank you, Judge.
Probable preliminary examination in person will be set September 26, 2023, this Tuesday, 9 a.m. That's before me. At this time, bond will continue.
Thank you, Judge.
Thank you, Your
Yes, that's it. Thank you. Court calls the case. People versus Devon Thompson.
Allie Zund on behalf of the people.
Assistant Public Defender Chelsea Virgils on behalf of Devon Thompson. Mr. Thompson, please state your name.
Devon Thompson.
Who's this? I met her the other day. Oh, okay, I just didn't recognize her. All right. Good morning. All right, what are we doing?
We'd like to ask to set the preliminary examination and address bond.
You may address bond briefly. Preliminary examination will be set October 3rd, 2023, 9 a.m. That'll be in person before Judge Barr.
This case brings us back to the issue of bond, and once again, the defense pushes for a reduction based on personal circumstances. Employment, responsibility, and willingness to comply are all presented, but the prosecution responds with detailed allegations of violence, including strangulation and repeated assault. That immediately raises the stakes. In cases involving alleged violence of this nature, courts are extremely cautious. The judge must consider not just the defendant's situation, but the safety of the alleged victim and the community. And when those risks are high, bond reductions become unlikely. This is not about punishment, it's about prevention while the case is pending. The court's role here is to manage risk, not determine guilt.
Thank you, Your Honor. We would like to ask for a bond reduction. Your Honor, my client is concerned about getting back to work. He would like to prioritize supporting himself, supporting his children, and paying his rent. He maintains a home on Forest Avenue. and would like to stay there. He is very confident that he can comply with any bond terms set, not to go near the complaining witness. So we would just ask if you would let him post 10% of a $10,000 bond or any bond reduction, really.
Response.
Your Honor, we would ask that bond remain the same. In this case, the victim went to his house to retrieve her belongings. She ended up taking a nap thinking he would be home for a while, and she was awoken by him on top of her, strangling her. While he was strangling her, he was demanding the password to her cell phone. She gave him the code to stop him from strangling her. He read her phone, became upset again, and then began to assault her again. He threw her against the wall multiple times, slammed her head onto the floor, kicked her in the face while she was on the ground. She tried to leave, but he would block her and refused to let her leave. She eventually escaped through a window and ran to try and get help. And we also would ask for a condition of bond be added as well, that there be a no-go to her work. And we also had a report from the victim that his family is harassing her in person and on social media as well.
That his family is?
Yes, Your Honor.
Any additional response?
I would just like to say my client denies that these events happened as stated, and I just ask for that bond reduction. I understand the charges are serious, but he is denying them at this time.
Motion for bond reduction is denied. Prosecutor, if you send over the order adding that condition, the court will sign it regarding work.
Your Honor.
All right, thank you.
As the proceedings close, we see the final decisions reinforce a consistent theme across this entire session: risk management over convenience. The defense makes one last attempt to ease conditions, but the court holds firm. The allegations in this case are serious, and the judge prioritizes safety and structure over flexibility. Looking at the broader picture, this entire hearing showcases how the legal system operates under pressure. Multiple cases, different circumstances, constant decisions, all guided by the same principles: fairness, procedure, and risk assessment. Some defendants receive leniency, others face strict conditions, but every decision is rooted in balancing individual rights with public safety. Judge Simpson's rulings reflect that balance throughout. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.